Yes, Mr. Parker. We're about to embark on Bank of India and Morris.
My lord, thank you. Tab 19 for Bank of India and Morris. Just perhaps a reminder rather than requiring the court to read it. The discussion of policy is at paragraphs 107 to 112, pages 368, 369, and a summary of the conclusion they reached with regard thereto is paragraph 120 on page 370, where it says the application of 213 requires a special rule of attribution in order to make it self-evident policy effective. The policy is to make those who have been parties to fraudulent trading liable to compensate the creditors of the fraudulent company. And what we say in paragraph 12 of our skeleton argument, as you will have read, is that whilst the court recorded the acceptance by Bank of India that outsider companies can be made liable under 213, there was no suggestion in the judgment that the court's view as to the effect of the language, context and policy of the legislation was in any way dependent on that concession. The court did not consider the policy of 213 was directed only at those with management or control of the fraudulent business. And it's that decision as to the policy that led the Court of Appeal to impose liability beyond the concession that the Bank of India had made. And as you will see, as you will have seen, set out in paragraph 38 of our skeleton argument, we say that it is very difficult to see how this court can proceed on the basis of that Court of Appeal's finding as to the policy of 213 and yet endorse the narrow construction. And we say as a consequence that ratio is binding on this court in the way that Mr. Justice Snowden in Bilta and NatWest found that it was. Mr. Justice Newberg obviously also relied upon the legislative history. We have seen what was said in the Cohen Committee, reference to people who are knowingly parties to the frauds. Lord Justice Lewison highlighted this morning. We say that that's an indication as to how the Cohen Committee, viewed the effect of the wording that was then in existence. That it was dealing with the conduct in question was being party to a fraud, but it was limited to directors, and therefore it was proposed to remove that limitation. And obviously, the committee didn't think that it was recommending an extension merely to those who were party to the management or control of the fraudulent business. Mr. Justice Newberger also made reference to the previous authorities. Now, to state the obvious, the principles of attribution can cause some confusion in this area. As Bank of India Morris itself shows, the issues that may arise are when one's considering whether an outsider company is liable, the question can arise is whether the conduct of an individual within the outsider company can be attributed to the outsider company so as to render it liable. That obviously was the issue in Bank of India and Morris itself, where it says the crucial question is whose knowledge in the company counts for the purposes of section 213. Similarly, if one is considering whether an individual within the outsider company is liable, the question can arise as to whether, despite knowingly being a party, his level of activity was such as to render him dishonest. He may say, well, I did know, and I was a party to, but the section requires that I be dishonest. And perhaps because of his status within the organisation, it would be open to a court to find, particularly being a discretion remedy, that because of those factors he wasn't dishonest. Bank of India makes quite clear, in addition to simple requirement of knowingly being a party, there has to be real moral blame. There has to be dishonesty. So that is a further complicating factor when considering the positions of individuals. And then finally, if one is considering whether an individual within the fraudulent company is liable, one has to bear in mind that the relevant fraudulent business, it has to be a business of the company. So that can give rise to problems of attribution. So with the salesman in Crown against Miles, you'll recollect that he was charged with having a managerial responsibility. And that's why there was a problem with the direction that was given to the jury, because it went beyond what he'd been charged with. But his response was to say, I was acting on orders. Now, acting on orders would go to the question of his honesty. If he was acting on orders, that would seem not to give rise to any problem about him being a party to a business that's being conducted with intent to defraud, because presumably those who gave the orders would have had the necessary intent to defraud. If you've simply got a salesman of his own volition selling in a fraudulent manner, that still raises the question as to whether or not that's business by the company, because you've got the question of whether the acts of the lowly salesman can be attributed to the company for the purposes of meeting the requirement that there be a business conducted with intent to defraud.
I'm not quite sure I'm following this. In Miles, as I understand it, the business of the company was selling worthless shares.
Yes.
And the charge against Miles was that he knew these shares were worthless and he was selling them. Why would that not be dishonest?
Well, that would, because that would... Well, his defence was to say he was acting on orders.
Yes.
Now, that aside...
I mean, if he said, well, I didn't know these shares were worthless, then that's one thing. But if he knew they were worthless, and he sold them, and that was the business of the company, leaving aside whether he's party to the carrying on of the business, I don't understand why that wouldn't be dishonest.
Well, I'm suggesting, I'm not deciding what's dishonest or honest. I'm suggesting that the reason why, in that case, the defence was that he was following orders was directed to submitting that as a consequence there shouldn't be a finding of real moral blame. Now, whether or not that submission would have succeeded or not, I'm not getting into. I'm just trying to point out what I suggest might be the relevance of him saying he was acting on orders. And because he was acting on orders, on the facts of that case, it would be difficult to suggest that there wasn't the necessary intent to defraud for that business to be held to be a company, a business being conducted by the company. But if you have isolated acts by lowly employees, then one can see there may be a problem of attributing that to the company so as to find that the company was conducting a business with intent to defraud. That's, you recall, Mr. Justice Hoffman and Augustus Barnett saying you've got to find one act and then you've got to find the necessary intent to defraud before you then go on to define whether the particular defendant was knowingly a party. So unless in Augustus Barnett, Mr. Justice Hoffman said, well, unless you're alleging that there are people within the company with the necessary intent to defraud, you don't then get on to the accessory liability question of a person being liable for knowingly being a party. And we, as indicated, we say that Crown and Miles, the issue before the court didn't arise because the response of the court was to focus ultimately upon the direction being overly broad when set against the terms of the indictment. Kellard, the learned friend, mentions in his skeleton argument, we've highlighted that the question that was asked there was whether or not Mr. Wright, who was the relevant defendant, was assisting in the carrying on of the business. And there's no suggestion there that Mr. Wright had to have management or control of the business in a generic sense. And we conclude with emphasising the importance of Regel Cooper chemicals. The court has seen how the submissions of Mr. Evans-Loam, and indeed the court identified how the submissions of Miss Evans-Loam were directed to the allegations that were being made. i.e. no allegation of management control, and the judgment of Mr. Justice Templeman was given on that basis. And therefore, a clear decision that management control of the fraudulent business was not necessary for liability under 213. And we highlight in our skeleton argument, paragraphs 21 to 29, the additional significance of that, not simply a matter that it's a long-standing authority of many, many years, but also it was a decision that was made prior to the change to the wording of the relevant provision that was made by Schedule 6, Paragraph 6 of the 1985 Insolvency Act, which didn't change the wording with which we're concerned, but did make a change from liability being by reference to the debts of the company to being by making such contribution as the court should think fit. And therefore, the 1985 Act was not a consolidating statute, and therefore the principle of re barris is engaged, as we set out in paragraphs 21 to 29, the skeleton argument, namely that there's a presumption that the legislature endorsed the court's interpretation of the wording that was reused in the non-consolidating statute. And obviously, we also make the point that insofar as my learned friend says that the original Section 75 was a corporate veil piercing provision, because liability was assessed by reference to the debts of the company, that went with that change in the 1985 Act.
I mean, how strong is the barrister's presumption when the decision you rely on is effectively a strikeout application?
I don't know. I haven't found anything.
I mean, it's one thing if this court, or even more so the Supreme Court, interprets a statutory provision, but the judge on a strikeout application allows the whole thing to go to trial.
Well, the presumption, as we identify in the skeleton argument, has been in one of the seminal decisions, was with respect to a first instance decision. In respect of your Lordship's point on a strikeout, we would say that if it's a point of law with a clear pronouncement of what's satisfied for the purpose of the section, that the presumption can apply. One might say it would be unrealistic to suggest that the presumption is as strong where there's a decision on a strikeout as it would be for a decision of the Supreme Court. And that might be said to be fairly obvious. But we say the presumption should be taken into account when assessing what the answer to the question before the court is. My lords, my lady, those are my submissions.
Right. So what's next on our agenda?
Still me, I'm afraid, my lord.
Yes, you're going now on to section 1032.
1032. The court will appreciate the significance of the 1032 issue relates to the applicability of Section 32 of the Limitation Act and how the two relate.
Yes.
The wording of Section 1032 we find in tab 69 in volume 3, the authorities.
Volume 3, did you say?
Yes, my lord. Tab 69.
I don't know why, but numbering on my bundles of authorities doesn't seem to correspond with yours. It's in volume 5 of mine, but not that matters.
Oh, you've got more volumes, yes, sorry.
Yes.
And so we have 1032 on page 1555. And obviously, our argument really begins and ends with the wording of the section, subsection 1. The generally effective and ordered by the court for restoration to the register is the company is deemed to continue in existence as if it had not been dissolved or struck off the register.
Yeah.
And that provision was applied by the judge in, we say, a wholly novel and overly activist way, as appears from page 176 in tab 17 of the core bundle. It's paragraphs 5 and 6 at the top of that page.
Say the paragraphs again?
It's paragraph 69, subparagraphs 5 and 6, top of page 176.
Yes.
Now, we say logically the only possible sensible alternatives consistent with the language of the section was one, to proceed on the basis that this was the rare case where the deeming provision ought not to be applied, so that you would proceed on the basis of the actual reality, namely that there was no company in existence, and therefore no possibility of the company discovering with reasonable diligence the fraud. The second possibility was to apply the deeming provision simply to the restoration of the company, but without deeming further that its directors were also put back in place. And then the third possibility was to proceed on the basis that the company had been in existence with the same directors it had had at the point it was dissolved. Now, the position we contended for at trial was the second and the third of those possibilities, because we say there's simply no basis from the wording of the section to proceed on the basis that the directors that had been in situ at the moment the company was dissolved were replaced by a hypothetical innocent director.
So just repeat your second possibility, would you? You apply the deeming provision.
And the company is deemed to have continued in existence,
Yeah.
but without any directors.
Without directors.
Because legally a company should have a director, section 154, but if it doesn't have a director, it's still in existence.
Yeah.
So you assume no directors at all during the period
Yes.
in which it was dissolved?
Yes. So the company is deemed to continue in existence, but with no directors. And that, the second possibility, company in existence with no directors, it is fair to say, was our primary contention in the first instance, on the basis that the deeming provision should not be extended more than was necessary. But we also ran as an alternative the fact that if the company was restored as if it had never been dissolved, then it would have had the same directors that it had at the moment of dissolution. And those directors were the dishonest directors whose knowledge was not to be attributed to the company.
What's the basis for assuming that they stay in office?
The basis for assuming they stay in office was the authorities to the effect that the restoration takes effect on an as-you-were basis, as if it had
that
never...
That does you day one. But what's the basis for assuming that they stay in office all the time?
Well, the assumption is that the company is restored with the same directors. Now, that assumption is on the basis, admittedly, of authorities that are dealing with companies that have continued to be active, and directors who were not actually directors at the relevant time have done actions, the validity of which is called in question. And the assumption is then made that because the company is being restored on an as-you-were basis, it's restored with those directors who therefore, throughout the relevant period, are deemed to have been the directors of the company, thereby conferring validity on the actions that they took. Now,
not all the cases concern actions taken by the company. There may be actions taken by third parties against the company.
Indeed.
So it's not just limited to
Well,
acts by people purporting to be directors when they weren't.
but I think in terms of the focus on the position of the directors, one gains more guidance when one's considering the validity of actions by the company. That one considers the directors to remain in office so that they were able, therefore, to bind the company to the actions that they have taken.
I mean, here, nothing happened.
No, my lord. Because nothing happened, and because one should not apply a deemed provision more than necessary, our primary position was to say, yeah, one can apply the deemed provision, the company can be deemed to be in existence. The reality was there were no active directors. And therefore, the application of the deemed provision, in the context of this case, can accord with the reality of the position, namely that there was nobody who could possibly have discovered the fraud during the period of the dissolution. Now, what we've said in our written skeleton for the appeal is if you apply the as you were directive, then for our purposes, that doesn't cause us a problem. Because if you proceed on the basis that the directors remained, because they were the dishonest directors, their knowledge is not attributed to the company. So we're still able to rely on Section 32 successfully. And we set out the relevant law, the principal authority we rely upon for that proposition of the directors effectively being treated as retrospectively reinstated because of the as you were, or as if it had never been dissolved position, say Timons and Craven, and there's no dispute as to what the relevant law and what the authorities say the position is. Save that, my learned friend says Davis and Frost is an authority for the fact that the directors are not retrospectively treated as having been reinstated. Now we say Davis and Frost never went that far. Davis and Frost is at tab 61. And Mr. Justice Adam Johnson addressed this. It's at pages 1359 to 1360.
Sorry, I got distracted. Could you give me the reference?
It's tab 61, pages 1359 to 1360. And there's a fairly substantial section there that's highlighted, paragraphs 387 to 393.
The argument that Mr. Johnson was dealing with is that, I think, set out at 376, paragraph 376. the effect of 10.3.2 is that Mr. Monks and Mr. Ford are deemed to have continued in post as directors. And that's the argument he rejects.
For the purposes of owing fiduciary duties,
he rejects that as the consequence of 10.32 for whatever purpose it is. For the reasons that he gives, which you've drawn our attention to. Do you say he was wrong?
Well, my submission is that in his reasoning, the judge is focused upon whether or not they owe fiduciary duties. The argument was they continued as directors. The judge responds to say, well, the real question is, did they owe fiduciary duties? Because you, the claimant, are seeking to hold them liable as constructive trustees on the basis they were directors in a relevant sense throughout the whole period. And the response we submit is the judge says, well, the real question is, did they owe fiduciary duties? And they did not. To owe fiduciary duties, you would have to have the relevant statutory power, which at the time you didn't.
Fiduciary duties to the company?
Yes. And he held that they did not. Now, he didn't actually say, it wasn't necessary to answer the question, could they have been directors in any sort of sense? Because in the cases where the company is restored, in circumstances where people have continued to act as directors, it is clear that the restoration operates as a retrospective reinstatement. So our argument was the deeming provision either results in no directors, our primary position at first instance, or if the directors are retrospectively reinstated in accordance with Timans and Craven, then they will be the dishonest directors whose knowledge isn't attributed to the company for the purpose of the Limitation Act. So on either argument, the deeming provision doesn't cause the claimants a problem. The deeming provision accords with the reality, namely that the company is not going to cannot discover the fraud.
Yeah.
Now, my learned friend's response, this is paragraph 38 of his skeleton, is to say that to have deemed the directors to remain in place is factually, quote, quote, factually unreal and absurd. Now, we say that, well, on that basis, one simply proceeds on the basis of the company being deemed to remain in existence, and one doesn't go the further step of deeming the directors to remain in place. But it's even more unreal and absurd to deem that the actual directors were replaced by a hypothetical innocent director. But more fundamentally, as a matter of legal principle...
Sorry, where does the judge deal with this no directors argument?
I don't think he does.
I must say, I haven't really appreciated that was your primary contention. I thought your primary contention was that the wrongdoing directors were back in the saddle.
I don't think he deals with our argument. He says that it is necessary, because of his view of the Limitation Act, to go further and deem that there be a hypothetical innocent director, which is at the end. That's at the end of subparagraph 6.
Yes, well, he says difficulty lies in identifying the persons who would have been in control. He doesn't say, well, the primary argument is that no one was in control. That's why that's thrown off the scent.
No, he doesn't deal with our argument.
Right.
The judge's view is either iteration of our argument means that the claim is not time barred. It's not time barred as a consequence of the company having been dissolved for a sufficiently lengthy period that the action was commenced within 6 years of being able to discover the fraud with reasonable diligence. And the judge doesn't like that. So he takes the view that the only way one can prevent that from happening is to deem that the company had the hypothetical innocent director. And we say there's no basis for that in the language of section 103.2. It's obviously, as I say, we begin and end with the language of section 103.2. We say the judge's operation of an additional deeming goes beyond what the section says. And that therefore the test is either one applies the deeming provision or one doesn't. There's no support anywhere for the notion that one invents a further deeming because of some particular concern that one has as to how the deeming provision is operating in the circumstances of the case. And
you say either one applies a deeming provision or one doesn't, but is it optional?
Well, this is the point of another friend's citation of ISC and Metroland. If the application of the deeming provision would produce an absurdity,
I see.
You don't apply it.
I see.
Which is why we say, well, if you don't apply the deeming provision, you're with the reality that there is no company. So during that period, it couldn't possibly have discovered the fraud. Which is why the deeming provision allows for, we say, the three possibilities that I opened with. But what it doesn't allow is a further deeming that the directors are changed. And on that point, we say, well, the learned judge doesn't even have, we say, the justification of these being special circumstances that would justify such extraordinary judicial activism. Because we say that the interaction of section 1032 and limitation periods has been addressed by the Court of Appeal in two decisions. And it's fair to say these decisions were not put before the trial judge, but then there had been no indication that the trial judge was going to deem the directors to have changed by being replaced by the hypothetical incident director. So the first decision that we relied upon, as identified in our skeleton argument, the relevant paragraphs being paragraphs 19 to 24, pages 22 to 23. We cite Regent Leisure Time and NatWest Finance, which we have in tab 55 of the authorities. Fifty-five.
Normally these questions are dealt with by direction, aren't they, under subsection 3?
Indeed, my lord. Now, at the beginning of the trial, the trial judge asked both sides if either of them were seeking a direction. And the response on both sides was, no, we're not. Now, Regent Leisure Time, as your lordship indicates, it is a case concerned with a direction. But the court would appreciate that the directions are sought, the basis for the directions being sought is complementary to the basic deeming provision, not for the purpose of going beyond the deeming provision. Now, this is a case where the company had been restored for the purposes of bringing a claim against its bank. And the registrar had made a direction that limitation period would not run, and Judge Overend had overturned the direction. An appeal was made to the Court of Appeal against his overturning of the directions and suspending the limitation period to enable the claim to be brought, which the Court of Appeal upheld the refusal to make such a direction, and therefore the claim was struck out as time barred. And the relevant paragraph that we rely upon from the judgment is at paragraph 90. And if the court be so kind as to read paragraph 90.
You give me the page
number.
Page number?
Sorry, it's paragraph 90, 90. page, I do apologise, 1195.
Thank you.
And also, it's interesting, paragraph 92, they disown the remarks of Judge Overend to the effect that the case had already gone on far too long. The district judge should have drawn a line on the basis that such considerations are the subject of the Limitation Act, and the Limitation Act either applies or it doesn't. So obviously we rely upon this, and so on the basis you apply the deeming provision, and then the consequence is that the restored company deals with the consequences as under the Limitation Act in accordance with the terms of the statutory regime, not on the basis that you favour a position where the claim is time barred. And we see further consideration of the interrelation in the case of County Leasing Asset Management Limited, which we have tab 58, dealing at page 1221. And perhaps if the court could be so kind as to read paragraphs 28 through to 30. So, highlighting the words in the middle of paragraph 30, the starting point for the achievement of this purpose in relation to limitation is to recognise that time would have run against the company if it had not been dissolved in exactly the same way as it did in fact run while it was dissolved. In the circumstances of this case, that should read, the starting point for the achievement of this purpose in relation to limitation is to recognise that time would not have run against the company if it had not been dissolved in exactly the same way as it did not in fact run while it was dissolved. And the reason being, because the directors, either because there were no directors on the reinstatement, or because the directors were the dishonest directors. And just to be clear, the proposition that the dishonest directors are not relevant for the purposes of a finding of discovery of fraud through reasonable diligence, that's Burnden in the Court of Appeal, which is at tab 59.
If the company had not been dissolved and had continued in existence, all sorts of things might have happened. HMRC might have thought it worthwhile to present the winding up petition earlier than they did. In fact, the directors might have repented of their wrongdoing. They might have been replaced by other directors who weren't wrongdoing directors.
My lord.
None of these are necessary consequences of the continued existence of the company, are they? They're just responsibilities there, things that might or might not have happened.
Well, yes, but on the basis that the deemed provision is applied no more than necessary. So either, as I say, you either have a company with no directors, or you have a company with the dishonest directors.
Well, both are assumptions, aren't they? They're both extra assumptions. One assumption is there are no directors. That's a positive assumption, which you rely on to say nobody could have discovered the fraud. The other assumption is another positive assumption, namely that the delinquent directors remained in office throughout the period of dissolution.
Well, the first is not a positive assumption. The first is a reflection of the reality of the position. Until the restoration, there are no directors. That's the fact. So the reality of the position is the company could not, with reasonable diligence, have discovered the fraud. You then have to take account of the effect, if any, of the deeming provision, which is that the company is deemed to continue in existence. So what impact does that have on the fact of the reality that it never actually had any directors? And we say you answer that by saying it doesn't need to have any effect on the fact there were no directors, because the deeming provision can be satisfied without consideration of the position of the directors. Simply accept the reality, there weren't any. Alternatively, if you work on the basis of as you were, what would be the position had it not been dissolved? The position had it not been dissolved is you would have still had the dishonest directors in place. Now,
I'm probably completely off the wall about this, but it seems to me, and I may well be completely off the wall about this, but I'm concerned about us just looking at this statute 2 provision in isolation, because everybody's agreed that what we're concerned about is the operation of Section 32. And Section 32 puts the burden upon the person who wants to delay time to demonstrate, A, that there was initially no trigger, and B, that with the exercise of reasonable diligence they couldn't have discovered if they didn't in fact know. What has the existence of dishonest directors got to do with those questions? I fully accept that for many purposes the knowledge of dishonest directors is not attributed. But am I just missing something completely basic, which is very possible?
I hope so, but I say the basic point is one is concerned with the company. Could the company, with reasonable diligence, what steps could the company have taken? And then this is the point that I may have been taken too hastily. Going to Burnton at tab 59, and it's paragraph 49. When one's asking whether the company might have discovered the wrongdoing, this is the judgment of Lord Justice Dave Richards, as young was, paragraph 49. He says, page 1246. The first issue is to identify the individuals who, on behalf of the claimant company, might discover the wrongdoing so as to start time running. It is, in my view, clear that it cannot be the alleged wrongdoers themselves. See Bilta versus Nazir. Now, this is a case, of course, where the dishonest directors of the claimant company were the ones that were causing the company to participate in the MTIC fraud. So when one's looking how to apply Section 32, could the company with reasonable diligence have discovered the fraud? You don't look at the dishonest directors. So if we posit a situation where the company had not been struck off, the dishonest directors would have remained in place. And you don't look at them for the purpose of applying Section 32.
But you are assuming that those directors, among other things, in that scenario, you're assuming that those directors do remain in place and that there isn't anyone else. I have to say, I'm maybe making the same error as Lord Justice Stuart-Smith by saying, aren't we looking at ultimately, the statutory question relates to Section 32?
Yes, you are, because, and we say what the Regent Leisure Time case says, is you don't seek to change the operation of Section 32 in light of how you want Section 32 of the limitation to operate in the circumstances of your case. So we stand or fall by the operation of Section 32. We have the benefit, in terms of the operation of Section 32, that we had dishonest directors.
And the consequence of that is that if the date of dissolution, you had dishonest directors, time doesn't run. Whereas if the day before either a liquidator had been appointed or dishonest directors had done a flit and someone else had come in and become a director, or there was one honest director left, time would run.
Yes.
That's nonsense, isn't it? Well, put it a slightly different way. Isn't that an absurd end result? Because it puts a premium on dishonesty.
It's not a nonsense. It's simply a consequence of the factual position. A
factual position which you're asking us to assume which doesn't exist.
No. Our primary position, so one either proceeds on the basis of the actual factual situation, there's no company, or one proceeds on the basis of a restored company with no directors, or one proceeds on the basis of a restored company with the same directors being restored. And then when one applies Section 32 to that situation, which is the situation in accordance with the deeming provision, we are able to take advantage of Section 32, consistent with the Regent Leisure Time and County Leasing authorities that say you simply apply the provisions of the Limitation Act to the consequences of the deeming provision. You don't then say, oh, well, we don't like stale claims, we don't like old claims, so we're going to have another deeming provision which effectively proceeds as if you'd had an innocent director installed prior to your being dissolved.
But isn't there a difference between this case and those two cases in terms of the consequence in those two cases was that limitation continued to run?
Yes.
You're seeking to use Section 1032, if I may say, it seems to me you are, to allow the clock to be stopped.
Yes, because that's what the Section 32 provides. If the company couldn't, with reasonable diligence, have discovered the fraud, time doesn't run. It couldn't. It didn't exist. So what is the effect of the deeming provision on that basic position? We say, well, because the directors were dishonest at the date of dissolution, time continues not to run in accordance with the Court of Appeal's decision in Burn. And what you can't do is say, well, I'm going to change the facts. I'm going to proceed as if an innocent director had been appointed prior to dissolution, or on the basis of a further deeming provision that if at the time of dissolution the directors were dishonest, we deem them to be removed in favour of a hypothetical innocent director. Because that's contrary to what Regent Leisure says. Regent Leisure Time says you apply the deeming provision and then the effects of the Limitation Act lie where they fall. And you don't always, therefore, you don't twist the deeming provision to ensure that the claim is time barred. And that is what we say that the judge in this case did. He added another deeming provision to distort the operation of Section 32 because he wanted the claim to be time barred.
Can I just ask you a couple of questions? Am I right in thinking that there's something like a 20-year time limit for applying for companies to be restored?
I think that's
gone.
6 years.
Still 20. Yes, it was originally 20 years.
Right.
It's now 6.
Right. And can I just ask you about how Section 1030 works? Page 1553, tab 69. Oh, I suppose that's perhaps I've answered my own question. That's for the purpose of bringing proceedings against the company for damages for personal injury. Questions of limitation do seem to come in Section 1030, subsection 2.
Yes, well, the limited, as Your Lordship indicates, that section applies in very limited circumstances.
Does that just affect the court's decision as to whether to restore it, or if there's a limitation?
Well, not in the circumstances of this case.
No. Is that what it's intended?
Yes. In effect, yes, that's an absolute bar of suggesting that the limitation period didn't run consequent upon the rest of the restoration. I mean, the reason why we took the court to paragraph 92 in the Regent Leisure Time case is the observation it isn't right for the court to proceed on the basis that the claim is stale or the claim is out of time.
Yes.
That's purely the provisions of the Limitation Act. And if it means, if the application of the deeming provision in the way we say it can only be applied means that the claim is not time barred, then that's a consequence of the extension that Section 32 of the Limitation Act allows for in cases of fraud. Yeah, because that's what Parliament has decided. Now, my Lord Justice Lewison picked up on a point that my learned friend made, which I was going to deal with in reply, but as Lord Justice Lewison's made the point, what about the possibility of HMRC having acted to restore the company at an earlier date? Now, the two things are, one, we have obviously been dealing with the reasoning of the trial judge. There's been no notice that he ought to have decided this point on different grounds.
No, I wasn't suggesting that HMRC might have restored the company. What I was suggesting was that if the company had continued in existence, HMRC might have presented its petition earlier. HMRC was presented the winding up petition, as I understand it.
My Lord. Well,
so without having to go to the trouble of restoring the company first, it might just have presented the winding up petition.
My Lord. But we say we're still concerned with the position of, I mean, it's a suggestion. I'm not aware it's been addressed by any of the authorities. As you appreciate from the paragraph 49 from Birmingham and Lord Justice David Richards, which individuals do look at. He confined his survey of the relevant individuals to individuals within the company, and we say that's the correct approach because Section 32 is concerned with whether or not the company could, with reasonable diligence, have discovered the fraud, which puts the focus on the actions of the company. And we would say the suggestion one looks to see what HMRC might have done is impermissible. Raises a question, for instance, what standard of activity is one applying to HMRC? Is one applying the standard of reasonable diligence to HMRC? Well, we say there's no basis for that.
That wasn't, I'm sorry, perhaps I didn't make myself clear. What I was suggesting to you was not that HMRC would have done anything in particular, but they might have. And so there are a number of consequences that might have flowed from the deemed continued existence of the company, none of which are required to be assumed by the statute, including no directors.
Well, one can the focus is the position at the time of restoration, we say. And then the company's deemed to be in existence. And as you'll also be the case, there's no other deeming involved.
Yeah.
So what, I'm not from the point.
I think it's a related point. You said your primary case before the judge was assume no directors. Just pursuing the point about we're ultimately trying to apply Section 32, and the question is whether the plaintiff has discovered or could, with reasonable diligence, have discovered. So you've got to restoration. We know there's a deeming provision that says basically the company is deemed to have been in existence, and nothing more than that. We've got to go, we've really got to go, we have to work out what attributes, if you like, should be given to the plaintiff in terms of section 32 for that period to determine whether it could with reasonable diligence discover the fraud. You're positively saying, in a sense, it's either no directors or it was the wrongdoing directors. But what tells us that it's that? And if it's no directors, does it follow automatically from that that company that is still deemed to exist, because that's the effect of the deeming provision, could not, with reasonable diligence, have discovered the fraud?
Well, there's nobody within the company to do so. And there's no, I mean, in terms of the suggestion, looking to see what might have happened vis-a-vis third parties, there's no basis for making an assumption that third parties would have acted any differently. Because we know the point at which it was wanted that the claimant should begin a claim. That's the point at which it was restored. But that's concerned with the actions of a third party. The company either had no directors at all, so it couldn't do anything, or it had dishonest directors who aren't the relevant people. You don't look to see what they could have done for the purpose of section 32. So you're left with nobody at the company that could, with reasonable diligence, have discovered the fraud. And in terms of the, I'm repeating myself, but my final observation on this point, in terms of the judge's reasoning, we say it's the deeming provision, or you don't apply the deeming provision. What you cannot do is then create a further deeming, i.e. a change of directors, simply because you don't like the result that it has for the operation of section 32 of the 1980 Act. Now, I'll try and be brief as I can, moving on to our ground of appeal 2. Ground of appeal proceeds on the basis that the judge was right to deem that there be a hypothetical innocent director during the relevant period. And the first...
I'm sorry, I'm just being very slow. I'm just looking at your skeleton argument for a moment. Paragraph 19. Sorry, page 19. You set out your ground of appeal. You say the judge erred in law in holding the deeming provision in section 1032. 1 required the court to deem that Nathaniel and Inline had directors in place, and or required the court to deem that those directors were not the individuals who held office. And then in paragraph 8 you say the focus of the appeal is on 2.
My lord, yes.
Doesn't, I mean, as I say, I was completely thrown off the scent. I didn't realise your primary argument was there are no directors at all.
My lord.
Was that, as you say, that was your primary case before the judge?
Primary case before the judge was no directors. Alternative was, well, if there were, they were dishonest.
Where are you saying in your skeleton, no directors?
My lord, that is footnote 3, my lord.
Footnote 3. That's the minority judgment, the dissenting judgment of Lord Justice Jenkins, is it? In Timons.
My lord, yes, because we submit that what he was objecting to the notion of the directors being treated as having been restored to their position.
Yes.
And we had to highlight that position is consistent with the principle that where a statute sets up some fiction, the courts are astute to limit the scope of its artificial effect. I'm citing Davis and Ford. So that was that the courts are astute to limit the scope of its artificial effect was the basis for us primary submission at first instance of no directors. And we say that but that, of course, that alternative approach, of course, provides no support for what the judge did. So it's either no directors.
Well, I understand what you say about the judge deeming there to be a competent director. I understand that, but you are still saying, are you, that no directors is the result of the deeming provision? Because I must say I didn't pick that up from your skeleton argument.
Well, that is, yes, we are still relying on that as an alternative. We're just saying the judge is wrong to have done what he did. We don't care which of the two alternatives the court thinks is the right one, because we get home, because on either alternative, we have the benefit of Section 32. The ground of appeal 2 is to say, well, even if the judge is right, the two things follow. One is that our pleading of reliance on Section 32 by reference to the claimants encompasses, obviously, the claimant acting through this hypothetical innocent director. And we will not ask for further particulars. So the pleading is sufficient to address the situation that the trial judge thought applied of the company being under the control of a hypothetical innocent director. That's the first point. And the judge was wrong, therefore, to terminate the inquiry at that point. The second point is that if one then looks to see whether there's any basis for refuting our position that the company could not with reasonable diligence have discovered the fraud if it had been under the control of a hypothetical innocent director, the answer is that clearly is not. Now, I'll try and be brief about this. Our argument before the trial judge was that the company could not with reasonable diligence have discovered the fraud of TFS because it needed to know two things. It needed to know that TFS had a sudden increase in the volume of its brokerage with respect to carbon credits. That's the first point. We said it also needed to know that the personnel at TFS did not think that that increase in the volume of trading had a legitimate explanation. And we said that to be in a position to infer dishonesty from the volumes required you to know, which one could only know from once one had the telephone transcripts, that they appreciated that there was no legitimate explanation for the volume.
You lost on the facts on that.
And this is on fact. This is a discussion of the facts. Now, his lordship rejected implicitly the submission that until we had the telephone transcripts, we could not know that the legitimate explanation that was being relied upon generally for the high volumes was known not to be a proper explanation. He rejects that. He proceeds on the basis it is sufficient if one could discover the volumes that TFS were trading. Now, our point was that the hypothetical innocent director would have no means of discovering the volumes because he didn't have the investigatory powers that the liquidator had. So the trial judge rejected our reliance on Section 32 by reference to what a liquidator could have discovered using his powers under Section 236. Powers obviously not available to the individual hypothetical director. So even on the basis of a hypothetical innocent director being deemed to be in place when the company didn't exist, the hypothetical innocent director was not in a position to discover the increase in the volumes that TFS were trading. That's obviously volumes it was trading with third parties generally. So the process is the claimant companies, they have their trading. TFSS is connected with some of that trading in a limited way. But the judge posits that if you had made inquiries generally, you could have discovered the full extent of TFS's trading. And Section 36 of the Insolvency Act would have enabled a liquidator to do that. And we set out the paragraphs where that appears from the judgment. And we say none of that could possibly apply to a single director without the powers under the Insolvency Act. That's our submission as to why, even on the basis of the judge's operation of the deemer provision, the appeal should be allowed.
Yeah.
Thank you.
Yes, Mr. Scory.
My lord, my lady, could I just pick up some points on 213 before dealing with 1032? Just 4 points to raise, if I may. The first, my learned friend began by referring to Augustus Barnett at A tab 9 at page 114, and the judgment of Mr. Justice Hoffman that an act was enough. The issue there being that one's not concerned with the business as a whole, just an act. The court will recall that was a strikeout case. It wasn't a final determined view by the learned judge. If one is being critical of the analysis, what the learned judge actually is takes the language and then reinvents it with a gloss all of his own, where it is rewritten. So with respect, one can't take any principle out of that and say that that is a definitive view that an act would be enough. It's also inconsistent with the Berlusconi case in the Court of Appeal. It also...
Sorry, which case in the Court of Appeal?
The, mispronouncing it,
Mephites, that one.
yes, exactly, Berlusconi,
That's
tab
it.
16. Yes,
Yeah.
sorry. And Mr. Justice Hoffman also generates this distinction between those carrying on the business and those parties to it, which, with respect, isn't contained in the Act.
Isn't what?
It's not contained in the Act. It's not what Section 213 does. So one can gain little assistance from Augustus Barnett. So put that to one side. The second point is, my learned friend said, and I wrote this down carefully, if one is carrying on its, if a company like TFS is carrying on its own business, it can be a party to the carrying on of the fraudster's business, and therefore there's no inconsistency between the two. Of course, there's no inconsistency only if one drops party to in respect of one's own business. Now, there's an illusion there. In theory, one needs to be able to apply Section 213 to all potential companies because it's concerned with the carrying on of the business in a certain manner. Therefore, it could, in principle, apply to both the insolvent company and the defendant. In that scenario, one has to pose a question. In providing the service to the fraudulent company, is one a party to the carrying out of the fraudster's business? But that posits the question that in providing that service, I am party to the carrying on of my own business. Therefore, one's back to the problem identified. How can the provision of my own services, my business, make me a party to somebody else's business? And of course, a party to the transaction, we're counterparties. But it doesn't mean I'm party to their business, just as a bank providing an overdraft to a plumber is not a party to the plumber's business in any meaningful way, it's providing its own services.
Why can't it be if it knowingly gives the loan to the plumber in the knowledge that it's going to be used by the plumber on a fraudulent business? Why can't that be partaking or becoming a party to? At the moment, I don't see why they're mutually exclusive.
Well,
I'm sure it's my fault, but I
no, my lord. If one takes the words of the statute, one is looking to the business of the fraudster. Is that being conducted in a way to defraud creditors?
Well, we take that as a given, because we've got that in this case. There's no dispute about that.
Then is one a party to that?
Is a person a knowing party?
Knowing, and well, put knowing to one side, is one a party? Because yes, there must be knowledge, my lord, but there can also be being a party to it without the knowledge. And that was one of the issues I raised in Recuper Chemicals, where it was all focused on the knowledge. But strip away the knowledge, and does it make sense to say that one is a party to the carrying on of somebody else's business? And with respect, no, I may be involved in it. I may be involved in a transaction. That's their business. I'm carrying on my own business. And there may be situations where the knowledge is such, take for example the BCI case, where the courts have said that the involvement was such that one moved from the arena of just providing, as it were, an interface between the two businesses by way of a transaction to actually becoming a party to the fraudster's business. But it's not just, and again, going back to the language, it's not just being party to the business in the sense that I have an arrangement and I know that's going to be used for fraud. I've got to be a party to the carrying on of that business. That's not simply then, as with a bank, the passive provision of finances, and I know not what they'll do, but I don't believe that they're particularly creditable businessmen. I need to be a party to the carrying on of that business. And one can't gloss over those words in my submission. The third point I wish to raise was by reference to the Bank of India at tab 19. My learned friend took your lordship and my lady to paragraphs 107 to 112 regarding the policy being addressed. In fact, it begins at 108. That policy was all directed to the issue of attribution and whether, in the very general terms in which it defined the policy of 213, the arguments on attribution would thwart it. With respect, it didn't deal with the policy at the granular level that we are seeking to address today at all. The fourth point is my learned friend referred to the Cooper Chemicals case. 2 points I wish to raise there. The first, with respect, the claiming companies didn't deal with my criticisms about what actually was the nature of the argument, because it's very clear what was being said by Harrison's. The second point is that there was reliance raised in express terms on the Barris principle. And to be clear, we don't dispute the principle, we do dispute its application in this case. And my Lord Justice Lewison asked, is there any assistance on that? Well, there is assistance in the Barris case itself about what is meant by a clear statement, and that, for your lordship's note, is in the authorities bundle at tab 2. And if one looks at page 21, below the second hole punch, there's a reference there to where a word of doubtful meaning has received a clear judicial interpretation. And with respect, the interim applications dealt with by the judgments we've looked at don't represent that clear judicial interpretation. And in terms of the clarity which is required, there is, if only of passing interest, the views of Lord Blainsborough, who in fact dissented, but provides an interesting insight into the workings of the House of Lords at pages 43 to 44, where he's referring back to what happened in his days as a pupil. And
43 to 44?
43 to 44, my lord. But there is some further guidance at Bundle A, tab 49, page 1068, which is Bennion at paragraph 24.6. Without taking the court to it, the gist there is one needs to have something clear and unequivocal, and one simply doesn't have that here. So little assistance from the Barris principle. That's what I wanted to say, my lords, my lady, on 213. Could I then move on to the 103 2-point and limitation? And in questions to my learned friend, the court has already identified the point which I wish to focus on, which is there is an interplay that's not previously been addressed between the deeming of 1032 and the factual inquiry which needs to be undertaken for purposes of section 32. And of course, it's the latter which needs to be satisfied, and there can be some friction when one tries to marry up those two. That, of course, begs the question, whose knowledge is relevant? It is said against me that once, I had thought it was said against me, that once revived, the relevant knowledge is to be attributed by those who were last standing. And it was the point raised by my Lord Justice Lewison, looking at the second ground of appeal and paragraph 8 on page 20 of the core bundle. We had thought that the first ground had been abandoned, and we had not.
Certainly not understood it to be in the forefront.
No, my Lord, no, and certainly I hadn't read footnote 3 to resurrect the first subparagraph of the ground at all.
But it was the primary argument before the judge, was it? Because I don't think he doesn't deal with that in the various paragraphs of his judgment.
If it were the primary argument, it may have been addressed with such speed that one will be forgiven for thinking it worked. But it is dealt with in the judgment. If one goes to paragraph 17, just
paragraph.
I'll take your lordship to it. It goes to paragraph 68 on page 174. There's a contention recorded there, my lord. No question of time bar could arise.
Yeah.
So that was the point. And then on page 69 sub 5 on page 176. He rejects the idea that time is running at all because there's nobody there. And no doubt that was informed by the judge's view, and I'll come back to this, that in terms of limitation, one is concerned with a factual inquiry, and causation is important, as we see it is with the override direction for 1032 subparagraph 3. And as a matter of fact, if I could direct the court to the finding of fact by the judge at 66, he found, as a matter of fact, that those companies had been abandoned prior to their dissolution. Therefore, one can't just deem them to be revived and it's the last man or woman standing because there was nobody there. And it can't be right that one deems a company to be there with nobody at the helm, and then later the company can say, well, nobody's knowledge is relevant in section 32, and therefore time's not run at all. And it keeps on, as it were, in abeyance until such time as somebody takes over the helm, which simply can't be right.
Forgive me for not knowing the answers. Is there any obligation on the owners of a company or so on to put directors in place? I'm just wondering how far this fiction extends.
Well, can I come on to that, my second point in a minute, my lord? The extent of that fiction.
I can contain my enthusiasm.
It's got 9 short points to make in general on the 1032. The first one, I think, is common ground, which is we are deeming here with a deeming provision. I think both sides are in agreement that when one's dealing with a deeming provision, one needs to exercise some care as to the extent. And we have referred to the article of Lord Walker, Right Against the Judiciary, at tab 71, where he's of the view that deeming something may be unhelpful, taken as, or another paraphrasing may be more helpful. With respect, in the facts of this case, may not shed any further light on what this court is meant to do. But it does give rise to the question, how far should the court go in the context of the deeming provisions? Then I move on to the second point, which is, in order to work out how far one goes, one has to determine the purpose of that deeming provision. Now, section 1032 is at tab 69, and it is, with respect, limited. That's at page 1555. All subparagraph 1 does is, on the restoration to the register, the company is deemed to have continued in existence as if it had not been dissolved or struck off. Thus, one treats the company, which was legally dead, as if it had been alive. As a result of that focus in the provision on the company, not the directors, but the company, the immediate consequence is that if that company is treated as having been in existence, well, the company is in default. It's not provided its accounts.
Say it again.
It's not provided its accounts during the period of dormition or interregnum between being struck off and being reinstated. And that's resolved in terms by subsection 2, whereby one deems a company to have existed. It is then forgiven for the fact that by dint of that deeming, it's going to be in breach. So that's catered for. There's nothing about the directors, and that's because they're not addressed by the deeming in subparagraph 1. That, in my submission, is telling about the limits of the fiction. It's on the company. And if it's revived retrospectively, it doesn't follow, certainly not necessarily, that the officers, erstwhile officers, are deemed to be put back in office, or deemed to be.
So you mean there's nothing, for example, relieving them from penalties for failures?
No.
To do things directors should have done?
Exactly. Now, that was addressed in Davis and Ford.
Yes.
Because one can see that the effect of the deeming extends as far as to reviving obligations, because those are waived by subsection 2 for the company. So that's how far the deeming goes, but there's nothing to reflect the same breaches that would exist for the directors, and that surely, in my submission, is because it's not caught by the deeming in subparagraph 1. It talks about the company. It doesn't follow if I deem the company to be back on the register, I don't necessarily deem the company to have reinstated its office holders. Not least because that would give rise to all of the potential conflicts raised in Davis, and also begs the question whether those officers, erstwhile office holders, want or can be reappointed to that position. Because if they could not, then one has another deeming upon a deeming. There is, of course, the catch-all provision in subparagraph 3, which makes it clear that it's not for all purposes. It's put back in the same position and all other persons, as nearly as may be. One can't fully reinvent the wheel. One's doing one's best. But one has to apply under subparagraph 3 anything more than is done automatically by subparagraph 1. And one sees in the context of the question posed by my Lord Justice Lewison on 1030, there, which is concerned with claims personal injury with a much shorter limitation period, or subrogated claims by or against insurers, there is a consideration as to whether one should restore, and if so, whether one should give a limitation direction by express reference to 1032 subparagraph 3. So, but those are extreme conditions, and I'll come back to that provision.
Is there any time limit for asking for a direction under 10323?
There is nothing expressed at all, my lord, no. No.
So it could have been asked for from the judge in this case, could it?
Well, the whether it could or not.
It wasn't, I appreciate it.
The judge offered
right.
Either party to make a request for it, and both parties expressly declined the invitation. On my case, because it was far too late and it could not be addressed properly. On my learned friend's case, because he didn't need it.
Yeah.
So we all moved on. And we, as it were, the issue stands or falls on section 32. The third point is that the ambit and scope of the deeming provision in 1032, when it's been addressed in the cases, has been looked at principally to situations where the company has been restored in circumstances where it was formally struck off, but the office holders remained in situ, indeed may not have realised the company was struck off. And therefore, those erstwhile directors, servants and agents continue to take actions and engage in commitments in the name of what transpired to be a non-existent company. Now, in those circumstances, it's relatively easy to see how the deeming can be applied to validate retrospectively the actions of those agents and servants. A fortiori, because they thought they were acting with authority on behalf of the company. And that paradigm example is Timons and Craven case, is exactly what happened there. And with respect, if one understands the scope of the deeming, that's a rather simple case, because it was simply an oversight, that it was struck off. And what one has in that scenario is, yes, there is a deeming provision, but the fiction is in some respects mirroring reality, because everybody thought the company existed, and it was simply a matter of regularising what had been done in the name of the company in the real world, but which was invalid due to an administrative oversight in terms of its name on the register. And in that context, where it's said at page 1091 that the deeming provision and subparagraph 3 can create an as you were position, well, that's because the as you were is very clear to see. It's all the actions that have been taken, in fact, are validated, and therefore you are as you were.
So if the fraudulent directors had gone on quite blissfully unaware that the company had been dissolved under their feet, the same argument might apply?
If they had gone off and carried on...
They'd gone on thinking that they still had a company.
Potentially...
So you've posited the example where honest directors go through and the court validates their behaviour retrospectively. I was just wondering what happens if the dishonest directors go on.
Well, in that scenario, if on the facts of this case, I can with some safety...
It was safely distant.
Because they abandoned it. But if they had been there, one can see the force of the argument that if one is simply trying to regularise what has transpired, then they were still there, pulling the strings, not realising the company was, as it were, off the register. If it's regularised, so it's put back, the directors are still there. And on the basis of the Burnden case, I fully accept that if it's a fraudulent director, their knowledge is not going to count for section 32. So in that scenario, this 1032 would mean that those directors are in fact still there, because one looks, as a matter of fact, what would have been the position. Now that would not solve the point I'm going to come on to, which is, well, they may deem to be there on the day the company was struck off and the day after. But as a matter of fact, would it be correct that they would have still been there 3 years on, when every other person in the supply chain had been visited by HMRC, had multi-million-pound assessments, and all those that did not come to the table, they had liquidators put in place. Now, I'm not straying into the facts, but of course that gives rise to the question, what would in fact have happened? And that, I'm going to come on to that, because that's critically important. Because what one can't do in the deeming is deem what would have been there for the entire period of dormition of the company. One needs to ask, well, what would have happened? Because that's a factual inquiry required by section 32. And you can't, as it were, duck that inquiry by the deeming provision in 1032. Fourth point to make briefly is that the fiction is equally easy to apply in a Jodrell and Peakstone type scenario, where all one is concerned about is the existence of the company at a given point in time. That case concerned the commencement of proceedings against a company. It transpired actually the company had been struck off. The deeming is we'll treat it as if we're always there, so the proceedings are valid and one can continue. Again, very rather simple case in terms of the deeming provision, and no difficulty with that, but doesn't help the situation here. The fifth point I made is clear that if a limitation override direction is sought, to be clear, is expressly disavowed here, it can, in theory, be granted pursuant to subparagraph 3 of 1032, and that is the Regent and Leisure Time case at tab 55. Now, one turns up that case at tab 55. What one sees on page 1195 is that any discretion to make such an limitation override is very limited, and one needs an extreme case.
Yeah.
This is not such an extreme case. Indeed, learned friend quite fairly, paragraph 21, obfuscation argument, tab 3, page 24, expressly concedes that they would not have been entitled to a limitation override. But the default position, I think the learned friend took the court to this in paragraph 87, is that one simply applies the usual limitation regime. Of course, one is applying that not at the date of restoration, not at the date the override direction is sought. One is looking to the position as at the date the company was struck off. And the reason why that's important is that then ties in with the causation analysis which is required, which is the standard approach to section 32. Could one actually have found this out? And that is repeatedly, that approach is explained by Lord Justice Briggs, as he then was, in County Leasing and Hawks at tab 58 of the bundle, beginning at page 1221. And if one looks within that paragraph 1229, paragraphs 30, 32, and 33, there he sets out what he describes as a causation-based analysis.
Well, this is all in the context of subsection 3, isn't it?
Oh, yes, it is.
So should we give a direction? And
If we are, one needs to engage in a causation base. With respect to this, one needs to engage in that causation-based analysis, because if one were to give a direction under subparagraph 3, one is in effect circumventing the normal operation of section 32, which itself requires such a factual investigation to what would have transpired. So this is simply ensuring consistency with section 32. And this was not overlooked by the judge below, because at paragraph 69 sub 3 of the judgment at page 175, the learned judge said that the approach under subparagraph 3 informed how he should look at and read the dealing provision in subparagraph 1, i.e. one just applies section 32. The sixth point is that, as I've already submitted, 1032 sub 1 says nothing about the position of the erstwhile directors. The court's already been taken to Ford and Davis. I shan't go through it again at tab 61, but that, with respect, is clear that one does not revive the currency of the tenure of the prior office holders, nor are they bound by any obligations. What is missing from any authority to which the claimant companies have pointed to is any mechanism or principle whereby a company is deemed to be in existence. The directors have no obligations and indeed are not reappointed. But there's some rule of attribution of knowledge, which means that one looks to the last directors who were dishonest and attributes their knowledge, which therefore doesn't count. There's nothing to support that. If one has a deeming provision that only deals with the company, that says nothing about the directors, under section 32, one doesn't need a deeming provision. It's simply a matter for the claimants to prove what would have happened post striking off until the companies were revived. Would anything have happened? It may well be that that requires, in terms of proof, nothing more than to say nothing would have happened, and then that can be found in evidence, and one could have pursued that in cross-examination of the witnesses. But of course, there's no evidence to that effect. That wasn't how the case was put below. And on the facts of this case, it's particularly difficult but for any such argument to be made in light of the finding by the judge that prior to being struck off, companies had in fact been abandoned.
Had in fact
been abandoned by the fraudulent director. So this is not a situation where the companies are struck off and the last person standing was a dishonest director. These were, as it were, orphan companies where the controlling mind had gone.
That is the finding of fact.
Yes.
The judge makes that. So you say, okay, they've been abandoned. The company is just sitting there in this deemed existence. How do you say the factual inquiry under section 32 then works? Doesn't work. You just say that nothing has been done to prove.
Your Lordship may find that an unattractive response, but it was my argument below, which is the liquidators and companies have not proved their case. And I tested it on that basis, and it was found to be wanting. And I say the same again in respect of the argument that if there are no directors, or even a fraudulent director in place on day 1, what would have happened on day 2, 3, 4, and 5? No evidence about that.
You'll leave aside fraudulent directors, because I think Mr. Parker has rather shifted his ground. I think his primary argument, whatever it was before the judge, now seems to be you make no assumption about directors. Therefore, you go to the reality of the situation, which was that there weren't any directors, and therefore there was nobody who could have discovered the fraud. Seems to be the way he's putting it now.
Oh, yes. And it is put that way to say that scenario is not catered for in Section 32 because there is nobody in place whose knowledge is relevant for the purposes of time ticking under Section 32. Now, that's, with respect, incredibly self-serving, but on a false premise, because what is assumed in that assertion is that there would have been nobody in place for the entire interregnum. Even assuming in my learned friend's favour that one assumes there's nobody in place for knowledge purposes on day 1, what is the position on day 2, 3, 4, etc.? On one view, under Section 32, they seem to have to prove, well, what would have transpired, and that can be investigated. And no doubt inquiries made of the revenue, possibly an investigation of those officers. None of that was before the judge below. Wasn't advanced, pleaded, no evidence to that effect.
So is what you're saying really that in a case where there's no basis for making particular assumptions about individuals who would be Mr. X, some identified person, whose knowledge would have been attributed to the company, and therefore you could go through a conventional Section 32 analysis, is what it comes to that you're saying there's a company here, it's got the burden of proving that Section 32 extends time, and it can't do it?
I would say there is a claimant here with the burden of showing Section 32.
Yeah, the claimants here.
Oh, yes.
They've got a company which is deemed to be in existence, where it's not right to make any positive further assumptions because it's all uncertain, and they have not proved that, for example, they would or could not have put an honest director in within a week, and therefore they've just simply failed to demonstrate that time should be delayed by Section 32.
That would be, as it were, the punchline of the submission. I'm keen to disabuse your lordship of the idea that I didn't know what was going to happen, because, of course, in the case I had against the other companies, there was a significant amount of evidence that I put to the liquidator that there were many people within HMRC and on the periphery of the litigation arena with these parties.
Yes, but we haven't got any findings to work with. So far as we're concerned,
no.
there aren't any findings. I mean, yeah, I'm sure you did a most wonderful job cross-examining every liquidator in sight into a cocked hat about what would have happened on the following Thursday, but we haven't got any findings.
No, my point, my lord, is that it wasn't a matter of not proving. No, this was a matter of investigation. That should not be doubted, because that is recorded.
Yeah, that I accept. But your case before us then has to be the burden was on them throughout.
Yes.
And at its lowest, they don't have any they don't have a finding that they've shown that they couldn't, with reasonable diligence, have known. And in the absence of findings, it's not open to us to substitute anything.
Oh, yes.
And you don't need the judges going to the existence of a competent director. You just do it like that. I think this is what I was groping after about half an hour ago.
Forgive me.
I may be slightly...
if I can, by way of exculpation of...
Who for, you or me?
The judge below, my lord.
All right.
My argument below was the liquidators had not proved their case. And at a certain point in the judgment, the judge could have stopped and said, they haven't. But he then went on and addressed the evidence he had, what he thought the presumed might have been. When it then came to the issue of Inline and Nathaniel, he there could have just said, haven't proved your case. By then going to the notion of a reasonably competent director, that was actually an indulgence to the claimants. Not on the facts of this case, but analytically, it was a step that need not have been taken because he could have just stopped at not proven. and he may well be criticised for that generosity. But it is, one could stop at an earlier stage, and I agree with your lordship that it's simply a matter of having proven the case.
I mean, speaking entirely for myself, given the fact that what we do know about this case highlights the existence of a problem, because the fraudulent directors are abandoned and so on and so forth. It may be thought to highlight the importance of not making any further assumption at all. With assumption, just say you haven't proved your case.
I'm more than happy to embrace that, with my lord, because that would also retain for my clients the benefit of the consequences below on the limitation, for example, assistance.
Right, got to point 6, I think.
7 point.
Did you say there were 10?
No, my lord, there were 9. They may be slipping. They may be thinning. On the 7th point is the point that I've just been debating with my Lord Stuart-Smith in terms of one looks just under section 32. It's a matter of proof, and there's no assistance to for the claimant companies. My 8th point is the idea that if one looks at a causation-based analysis for causation under section 32,
You've given us that already.
in discussion, so I can move on from that. Following on from the point that it's an absence of proof and no attempt has been made to prove the requirements of section 32 by reference to what would have transpired but for the dissolution. It means that the second ground of appeal necessarily falls away. It's a matter of what evidence was adduced and how the case was put, and it simply wasn't put on that basis. One can't criticise the judge for not addressing issues which were available on the evidence before him. So that is the short response. And to the extent that I need to deal with the criticism about what an ordinary, prudent director could have done, it's my submission that their argument's not open to the claimant companies. What one needs to do for a factual challenge is very clear in Volpe and Volpe. There's been no attempt in this appeal to set out what the learned judge should have done and what the factual findings should have been. Because the problem was there were no underlying factual building blocks to make any findings, because the case wasn't presented on that basis by the claimants. And therefore that's an unfair criticism of the judge, and indeed not open for them to make it. Just note in passing that whilst it's said here that the director would have less of a chance of finding out about the true facts than the liquidator, it was exactly the opposite which was run with such vigour in this court in the OT computers case, where it was said that liquidators may have the powers, but they don't have the same intelligibility as a reasonably competent director. And I just raise that point because even if one were to entertain the second ground, one shouldn't assume in any way that a liquidator would find things out quicker than a director. The usual argument is to the contrary. Unless I can assist further, my lady, those are the points on 1032.
Thank you very much.
My Lord, what I propose is to let you have the relevant sections of our closing submissions on 1032, which refer back to what we said reasonably substantially in our opening. So you can see that the submissions I made about the options that were made before the trial judge. Listening to my learned friend, I'm conscious of the fact that, as I say, we've had no notice that the decision of the judge on 1032 should be upheld on additional grounds. And in our submission, the one ground that the judge relied upon was the notion of a deeming of a hypothetical innocent director. And in terms of Malone and Friends submissions about a failure to produce evidence and the like, we're not sure on this side the extent to which that was developed in the context of a response to the applicability of the deeming provision. Now, in that context, it is important to look at what the judge said on page 174. In subparagraph 1.
Paragraph 69 one.
Paragraph 69, subparagraph 1, because there the judge finds, and there's been no challenge to his finding, that without a consideration of the deeming provision, Section 32 didn't assist TFS. So the point about the companies didn't exist and therefore they couldn't have discovered the reasonable diligence, could not with reasonable diligence have discovered the fraud, was accepted without any suggestion that the court needed to consider what third parties such as HMRC might have done. So the judge then went on to see whether the position of TFS was assisted by the deeming provision, and as we've seen, he held that it was because of the deeming of a hypothetical innocent director. So it's not a case of our failing to adduce evidence on the point. So we've got this finding from the judge, and it makes perfect sense because we could hardly adduce evidence as to what third parties did in circumstances where the company had not been restored for the relevant period.
So you say that in 69 subparagraph 1, the judge made a finding that there was no claimant who could with reasonable diligence have discovered the fraud. He could have stopped at that point. And if you're right on the first way you put the case, the deeming provision doesn't alter that because it tells you nothing about directors.
Well,
yeah.
And then in terms of the judge's decision, we've simply got the hypothetical innocent director. Appointed in effect from day one. Now, of course, insofar as Malone and Friend points to the county leasing case, that's a judge's consideration of what the actual agents of the claimant would or would not have done. There's nothing about let's ask in the question of what would have happened on a hypothetical basis of the directors of the claimant company being changed by third parties. And we come back to the fact that Section 32 is concerned with what the plaintiff, with reasonable diligence, i.e. the reasonable diligence being exercised by the plaintiff. It's not concerned with what would have happened if third parties had acted in such a way as to change the directors of the claimant company. And obviously, that position is assumed to be the case in paragraph 69, subparagraph 1 of the judgment. As things stand, the claimant submission is entirely correct. The only question is, can TFS's position be saved by the deeming provision? And the route the judge took was to assume to assume a restoration with a hypothetical innocent director. Thank you. Now, Lord, would you like me to start costs, or shall we save that for
As you like. I think we might as well start. We might as well have 15 minutes or so on costs. No, we know there was a settlement agreement. We know what it says. There's no need to refer to it unless you absolutely have to.
Thank you. The costs order. The costs order itself is at tab 21 of the core bundle, page 230. And the cost judgment itself, you will have read, as your Lordship stated at the beginning, it's at tab 19. Now, the cost award is predicated on the fact that the parties hived off certain issues which were the subject of the settlement agreement. Now, those issues were whether the directors of the claimant companies were engaged in an MTIC fraud, whether the defendant dishonestly participated in that fraud, and assuming those two issues had been made out, the quantum of any recovery in light of those findings. All those issues were the subject of notices to admit. And obviously it's not all or nothing, because issues 1 and 2, the directors of the claimant companies involved in the MTIC fraud and the defendant's dishonest participation could have been admitted, but with the question of the quantum remaining open. It's also worth noting that the judge treated the claimant's costs on a collective basis, first of all in accordance with the facts that the settlement agreement had been entered into on a collective basis. The same terms applied to all the claimants. And that is a point that the judge makes in the judgment, paragraph 10, tab 19, paragraph 10.
Why is that relevant?
So why was that?
Why is it relevant that the settlement agreement was entered into on a collective basis? How the claimant companies distribute their monies between themselves is up to them, isn't it? Why should it have any impact on what the defendant has to pay?
No, it didn't. It's simply in the consideration of the relevant cost order on the basis of the judge's division. Then obviously the cost award should be the same in respect of all the claimants, because all the claimants are treated the same way under the settlement agreement. If one works on the basis of consider the position up to the date of the settlement agreement, then obviously it's going to be a situation where you don't distinguish between the costs of any of the claimants because they're all being treated the same under the settlement agreement. So my submissions on that basis as we go on are on the basis that the costs, for the reasons I will adumbrate, the cost should have been awarded in favour of all the claimants.
So the effect of that is that 3 claimants whose claims fail completely get all their costs.
Yes, Lord. Now, if this court exercises its discretion afresh, then the question of whether or not the cost should be on a collective basis obviously can be looked at again, and obviously it would be open on the exercise of a fresh discretion for the court to proceed on the basis of the costs of each individual claimant being considered. So I'd accept that, but just saying in terms of the judge's approach, it was a collective approach. Judge divided, as I say, he divided the costs into 2 periods of time, those up to the settlement agreement and those thereafter. No one is suggesting that he was not entitled to do so. And we will submit it's a fairly obvious thing to have done. The judge, doing so, excluded from any suggestion of any cost award, consistent with the position that we adopted, the costs of Mr. Hellard's witness statement directed to the limitation issue. The judge held that that was not a helpful witness statement, and in those circumstances it was accepted there could be no suggestion of the claimants having the costs of those witness statements. Now, the defendants make the point, in opposition to the broad separation pre and post the settlement agreement, that they had run their limitation defence, the entirety of the proceedings, and therefore some costs would have been incurred on the limitation issue prior to the date of the settlement agreement. But we say the judge's approach in making a cost order by reference to the specific date of a settlement agreement accords with CPR 44.2 subsection 7. And we have CPR 44 in tab 85. Maybe this court knows precisely what 42.2 sub 7 mean is.
Which particular part of the order?
We're looking at, it's page 1766, looking in particular on page 1767, at subparagraph 7.
Yes.
So before the court considers making an order by reference to a distinct part of the proceedings, it will consider whether it is practical to make an order under paragraph 6A or C instead.
Yes.
And 6A is cost from, C is cost from or until a certain date.
Yeah.
So we say, obviously, that's highly beneficial in terms of the cost of an assessment if the court picks a date and deals with the costs up to that date as one block and the cost thereafter as another block, without being mandated or being obligatory to take account of any minor costs that one of the parties may have incurred on an issue on which it ultimately succeeded. So we say, with that slight tweak, the approach that was adopted by the judge, it was consistent with what's been called the salutary rule in the case by the Court of Appeal in McEwen and Langer, which we have at tab 84. And that reference to the salutary rule appears on page 1762 of the Judgment of Lord Justice Green, paragraph 37.
This is about timing, this particular point, isn't it? And if I remember rightly, what had happened in that case was that the judge decided some preliminary issues, but there had been a call-to-bank offer, so he didn't know whether there was going to be ultimate success. But he decided to make a cost order in relation to the preliminary issue. And the complaint that was made to this court was, well, he shouldn't have done that. He should have reserved the costs until everything had been decided. Then he could have compared that with the call-to-bank offer and decided whether to make a cost order or not. So what Lord Justice Green is saying in 37, particularly by reference to Mr. Justice Nugent, is that those who lose discrete aspects of complex litigation should pay for the discrete applications or hearings which they lose, and should do so rather when they lose them, rather than wait till trial. That's the point he's making.
Well, look, we say these observations are applicable to the situation before the trial judge because the parties had determined by settlement the three issues that I've just outlined, as if there had been a trial of those issues as a discrete part of the proceedings. And therefore, if rather than by settlement, those three issues have been determined by a trial, then McEwen and Langer says that the costs would then be awarded at the conclusion of the trial.
So the logic of that is that you'd get either, you can argue about whether it's all or a proportion of the costs of the settled issues, but you would also have to, in the pre-settlement date period have to cater for the fact that because you lost on certain issues after the settlement date, that has effectively a retrospective effect because those issues were live before the settlement date.
My lord, that would be the case if there was an issue which clearly had taken up a substantial amount of time and costs. And we say that the relevant issues, obviously, our submission will be, with respect to those three issues, we were the successful party by reference to the terms of the settlement. The only element of the costs that we say we weren't successful on related to the limitation defence, which at that time was a relatively small amount of costs. It's when one gets to the trial that then takes a lot of time. And we say the judge was entitled to disregard, it would have been entitled to disregard those limitation costs because of the benefits, as indicated by 44.2, of picking a time rather than having an overly complex assessment by reference to each individual issue. But having said that, of course, we wouldn't be here if the judge had agreed with us that we were the successful party on those three major issues and had made a deduction from our learned friends on the limitation issue. The big question is whether or not the judge should have been awarding costs on the basis that we had clearly been successful on those three issues, namely whether the directors of the claimant company participated in emptic fraud, whether or not the defendants were dishonest, and the amount of recovery.
And on that, never mind the exact figures and percentages, which we're not mentioning. You say you were substantially successful and you had to incur the costs to get that far.
Yes.
And so if you're going to do, and there wouldn't be any more costs relating to those issues after the settlement date.
Yes. And we should not be deprived of our costs simply because that position was reached by settlement rather than by a contested hearing.
So
now,
if you've got a judgment for the sum that you got, reached by whatever means it might have been reached, for the sum you actually settled, then you'd say, well, we fought those three issues. We have been, I think you could, without being too controversial, say significantly or substantially successful, and therefore we should get either all or a proportion of those costs attributable to those issues.
My lord, yes.
And then you couldn't complain if you got a costs order which said that the costs of the issues that you lost, both so far as they were incurred before and incurred after the settlement date, should be the defendants.
Correct. And we say this wasn't a case. This was not a case of the judge taking his as a starting point that we had won by settlement rather than contested hearing, and then looking to see if there were countervailing factors that led him from that starting point not to apply the general rule of costs following the event. He simply didn't reach a decision as to whether we'd been successful because he didn't take account of the terms of the settlement. He said he couldn't apply the general rule because he didn't know whether we would have won had there been a contested hearing, and he didn't know what motivated the defendant to have reached the settlement.
Well, both of those are probably factually true.
Factually true, but they would apply. But the first would apply equally if there had been a settlement of all issues on the basis of the terms of the settlement with a payment to follow. And we say it would simply be wrong to say that the general rule should be applied if we have been successful by a contested hearing, but it isn't applied if we've been successful by virtue of a settlement. And Lord, we say that when one looks at the authorities, Lord Neuberger is clear that when the general rule applies, if there has been success, if there has been a vindication of the claimant, whether it's by way of a contested hearing or whether it's by virtue of a settlement.
If the judge had ordered TFS to pay the costs of Nathaniel and Inline, but had ordered Bilta, Western and Vehement to pay TFS's costs on the ground that their claims fail completely, could you have quarrelled with that?
My Lord, yes. Yes, we could, my Lord. We say that in the circumstances of a case failing on a procedural defence of limitation, the order that the just order is no order as to costs.
Really?
Yes, my Lord, because the substantive issues of dishonesty have been denied. One's had to fight those issues. They could have been admitted. It's not a situation of the defendant saying, well, we'll concede the question of dishonesty of the directors claimant companies, we'll concede our own dishonesty, and we'll concede quantum, but we are going to fight the issue of limitation. If that was the situation, obviously we'd be paying all the costs of the proceedings. But in circumstances where we have been forced to establish the dishonesty, in those circumstances, we say the normal, I can't say normal, I don't know what every cost order that's ever been made. I would say that the just order in those circumstances is no order as to costs. Happens to be it's the order that was made by Mr. Justice Miles recently in the errored case of a case of fraudulent misrepresentations established, but it lost on the basis of limitation defence.
And that resulted in no order, you say?
That resulted in no order.
Well, that's what the judge did here. No order.
No, my Lord. He made, in respect of the proceedings on the three issues, which we say we were successful on, he made no order against all the claims.
Yeah.
And as I say, if the order had been costs in favour of the successful claimants, no order in respect of the failed claims, then one could see the sense of that. What we say is one cannot see the sense of the situation where even the successful claimants receive no costs for having been successful on those three issues. All those costs were incurred to get to a position where those issues have been established. And simply because that position was reached by virtue of a settlement, rather than by virtue of a contested hearing, we didn't get our costs. Now, obviously, if this court, looking at the terms of the settlement, doesn't think we were substantially successful, then my submission fails. But we say, if you look at the application of the general rule, in the usual case of a claim for compensation or damages, then applying the terms of this settlement to such a claim, we would be treated as a successful party.
Yep.
And we shouldn't be deprived of that simply because we arrived at that position by virtue of a settlement. So we say...
And your main point is it wasn't necessary for the judge to attempt to second guess what might have happened had all the issues gone to trial. He should have been able to tell from the settlement agreement itself what the outcome was.
That's all he needed to know.
Yeah. Right. Well, would you like to continue this tomorrow morning?
Thank you.